Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in our case number CV23-0744, Chandler versus Roosevelt Water Conservation District. These proceedings are being video and audio recorded and live streamed. So we just ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes to present argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you want. Please keep in mind that we've read the briefs and conferenced the case this morning, and with that, we can get started. Mr. Henry?
Good morning, and may it please the court. Robert Bob Henry from Snell and Wilmer on behalf of Appellant Roosevelt Water Conservation District, RWCD in the briefing. I would like to reserve at least 5 minutes for rebuttal. This is a dispute regarding the enforcement of a contract barred by the statute of limitations for claims against public entities. ARS 12-821 is the statute that requires that all claims against public entities be filed within 1 year, and RWCD, being a public entity, afforded that protection. This all relates to claims brought by the City of Chandler, the plaintiff below, against RWCD that arose more than 1 year, indeed more than 4 years before Chandler indeed filed suit. All this arises out of a 2002 contract that RWCD contends, and RWCD submits that the evidence supports that the parties, including several third parties, critically intertwined with the contractual relationship, such as the City of Mesa, stopped performing under as far back as 2009.
Counsel, Chandler asked at various times over the years, for the contract to work, and each time they were, rebuffed. Wouldn't each instance start the clock running again?
Great question, Judge Howe. Ultimately, that's going to be the accrual theory of things in this case. What I'm trying to establish up front is whether 821 applies or not, and that'll get into the builder's supply argument that I'll touch on in a moment. But as a factual matter, there is a large period that we think the record supports from 2009 to about 2018 where there was no activity by the parties to this dispute under the contract. It was only after the RWCD sent a notice in or around April of 2018 advising Chandler that it was considering the contract terminated that the City of Chandler then continued to send, I would call them ministerial notices, changing of contact person, the same letter saying we'd like to have water, the same letter would get sent back in response saying we consider this relationship terminated and what have you. I don't know if that answers your question. I don't want to move on without answering it.
What is the status of the payment of assessments by the city? When was the last payment made?
Under the contract as originally construed, my understanding is that the last payment would have been in or around 2008 or 2009. After that, there's a dispute about what Chandler was paying for and what water it was being given and what have you. But under the contract, the mechanisms of the contract, the last payment, as I understand, and I'll find the record site in rebuttal if need be, it was quite a long time ago. So after RWC sends a notice in April of 2018, the parties go back and forth, but there is no dispute. There cannot be a reasonable dispute that from April 2018 or early 2018 forward, RWCD was not acting in any manner under and pursuant to this contract. And I think that plays into a builder supply issue in a minute.
Your argument is that at that point in time, there was a sufficient controversy for purposes of declaratory judgment action, and that starts the clock running, right?
Absolutely, 100% true.
What do we do with cases or a line of cases that say just because you have a justiciable controversy for purposes of a declaratory judgment action, that doesn't mean that you have sufficient injury for purposes of accrual? It's the Rio del Canyon versus Flagstaff case, I think, is the latest example of us saying that.
I think so. I think the Canyon, Del Rio, and maybe the Rogers case, but whatever the issue, as this court has itself said, as to when a declaratory judgment action accrues is less than clear than in other instances. We will concede that. But we think under the Canyon Del Rio and other authorities that have tracked that case since then, the litmus test is when should the other party know or reasonably should know that there's a controversy? Is there something in dispute? And I can't think of a more clear declaration from one side to the other that there's a dispute about the continuing validity of a contractual relationship than the letters that started in April of 2018 and continued annually thereafter.
Is that so the litmus test that you've identified, is this unilateral letter from one side sufficient, or doesn't there need to be some, repudiation or response or something on the other side that we are looking for to kind of seal that point in time?
I think that's a great question, and the answer, though, is really what is the test? When should the other side know that one side to the dispute, whatever it may be, is disputing any further action, whether it may be, under a property law, whatever the theory may be? When should the other side know that the other party or parties, as the case may be, has declared that there is a controversy? And again, I go back to, I don't know how you could be more clear than what RWCD said.
Well, at that point, the district has anticipatorily repudiated the contract, right?
As the city of Chandler expressly stated themselves.
Right. But the city, before there's a breach, under the case law talking about repudiation, there's not a breach until Chandler accepts it as a breach. Once there's a repudiation, Chandler has a choice. It can either say you've breached and we're going to sue you and actually do that, or it can say that's nice that you've repudiated, but we're going to continue to urge you to perform and hope that you do so. So which box do we fall into here? Well, I guess assuming you accept that as the legal framework to begin with.
Well, respectfully, I'm not sure that's the entire framework at issue here. I think the issue then becomes when under 12-821 does the cause of action against that public entity. Right. We may be taking declaratory relief claims outside of the public entity realm a little bit here. But when,
let's say I read Canyon Del Rio to say you don't just need a controversy, you need a breach. Where does that leave us?
I think there's a breach in 2018.
Based on repudiation or?
RWCD was asked to perform. It did not perform. It expressly said it would not perform. I cannot think of a more clear breach than that.
So a breach doesn't have to be recognized as a breach by the other party?
There are two responses to your great question. First, it was recognized. In fact, the city of Chandler expressly stated, we are going to consider this to be a breach, and we will take exert all available legal remedies in, I think, 29 days later. And from that point forward, I believe the case law is pretty clear that the city of Chandler, for purposes of claims under this contract, was on the clock. And I think the date is somewhere around May, June 2018. It doesn't matter. They didn't file suit until September of 2022.
Could they have just thought, I mean, they asked periodically for water, which is inconsistent in a way with recognizing there's a breach. They're hoping that your client will fulfill. So they're not yet ready to declare a breach because they keep asking.
Well, I can't put myself, nor can I put my client in the shoes of what they were hoping for. All I can say is what the record shows. And if that was their hope, I think, I forget the case, but that may fall into the category of wishful thinking. This wasn't like we are considering not performing any further. This was one party to a contract saying to the other party to the contract that we consider, and let's go back to the chronology and history here, we consider this relationship to have been effectively ended almost a decade earlier. We are sending you this notice to make clear we will not perform any further from this point forward. And the record shows that, in fact, from that point forward, RWCD did not perform.
Right, but then the city responds to that notice from the district, and it says in the last paragraph of its response letter, the city believes that RWCD's announced and unjustified termination of this agreement on May 26, 2018 constitutes anticipatory breach of the agreement. Should RWCD decide to reconsider its position and withdraw any threatened termination, please notify us or notify me immediately. So that seems a little equivocal to me. And then later on, the city continues to send correspondence requesting or urging performance under the agreement.
And I'm going to respectfully ask for your indulgence for me to find the record site, but I'm pretty sure that in response to that letter, if not in that very letter, every year thereafter, RWCD made it clear that it was not going to perform. The same basic correspondence went back and forth for 2-3 years. I don't know how any recipient of these letters could reasonably conclude that maybe RWCD is going to revisit its position. And really, if you take it to its logical conclusion, and we make this argument in our briefing, under their theory, the city of Chandler's theory of this case, they could sit on this case until 2085 and then say, now we want it. And here's our relief that we request under the agreement. Because, you know, back and forth, we keep sending the same letters, you keep sending the same letters back and forth. Let's just play that out. That's an absurd result.
So let's talk a little bit about Nolus Tempest, because I think you tried to start there and we got sidetracked a little bit. But what do we do with Trimble?
Well, Trimble, first, nothing screams, let's have some fun, than talking Nullum Tempest on a Wednesday morning. One, Trimble itself limits Nullum Tempest to actions by a governmental agency acting for the public benefit. And we've cited numerous cases, and I know there's contrary authority in different contexts about the governmental proprietary distinction. But Trimble itself, if you read Trimble, stands for the proposition that it doesn't apply outside of actions by a governmental entity for the general public. And I'll go into the reasons, I think it's in our briefing, as to why we don't think that this is an action by the city in its governmental capacity. Second, Trimble also dealt with a statute of limitations under Title 44. Okay, and Title 44 does have, and we cited this in our brief, another provision that says that notwithstanding, I'm paraphrasing, so please give me some indulgence here. Notwithstanding any other provision, you know, the parties retain all rights under common law. Okay, and common law would necessarily include, by definition, the common law doctrine of nullum tempus. So that's one issue. Second,
Well, I think the chapter that 821 falls under also preserves the common law, doesn't it?
if it does, I'm not aware of it.
I mean, I guess, so we have Glen Eyre Electronics on one hand, which the language says notwithstanding any other law, the statute applies, and the Supreme Court said that was enough to circumvent nullis tempus. And then you have Trimble that says no civil action, and our court said that's not enough. That language is not enough to overcome nullis tempus. Which bucket would you put our statutory language in, and why? I suspect it's Glen Eyre Electronics.
Well, yeah, well, respectfully, I have the best answer to your question is you've got a conflict between what the Arizona Supreme Court has said and what I believe the Arizona Court of Appeals has said. And we have the Arizona Supreme Court issuing the later decision on the issue.
What is that conflict?
Well, I was trying to frame it as you were questioning me. I don't think there is a conflict. I think Trimble is limited to ARS 12.510 and nullum tempus in that regard. But regardless, I think you have hit on the case that really does dispose of and renders moot all of the city of Chandler's arguments regarding nullum tempus, and that is Glen Eyre. And Glen Eyre approached an issue as to what does the legislature mean when it has a statute that says notwithstanding any other statute, and the Arizona Supreme Court didn't even address the fact that it says or the common law. It says that notwithstanding any other statute, that is a clear direction from the legislature that whatever follows in that provision, that statute, trumps anything else existing. And Glen Eyre stands for the proposition that when the legislature uses language like notwithstanding, or in our case, 12.810 or 821, all. I mean, all means all. They go into a whole semantical analysis in that opinion in Glen Eyre as to what notwithstanding means. And I think they even trail into notwithstanding means any, and any then means all. And you really then follow yourself down a rabbit trail where notwithstanding is, there can be no broader word than notwithstanding, or in our case, all. When the legislature says all, it means all. And when it wants to carve out things, like it did, for example, in 12.510, for statutes of limitations prescribed in that chapter, it expressly says so. So when the legislature comes in and says, for whatever reasons, the legislature in its wisdom sees fit that all actions against public entities shall be brought within 1 year, I cannot fathom a more clear directive. And I think that, back to your nullum tempus question, that takes it outside of nullum tempus. And if not, under Glen Eyre, and as Glen Eyre clarifies things, at least by necessary implication, takes nullum tempus out. If the legislature had meant something other than all, it would have used some other language other than all. And I think Glen Eyre is also the opinion, I may be conflating things here, where it says we're not going to ask the legislature to use magical words or meanings. When they want to say something, they are capable of saying something. And who are all of us to then say to the legislature, yeah, maybe 15, now we're 30 years or so later, 40 maybe, say they didn't mean all. They meant some, or most, or many. All means all. Goodness gracious, I've lost all my rebuttal time.
No? You want to preserve minute 45?
I would love to preserve. If there's any other questions, though, thank you.
Thank you.
Good morning. May it please the court, Sean Hood, Fenimore Craig, on behalf of the city of Chandler, joined by my colleague Taylor Burgoon from the city of Chandler. We have Simone Joles-Rude, Water Resources Advisor, and we have Don Gingrich, Assistant City Attorney. I'm prepared to start on Nellum Tempest, unless you'd like me to start with builders.
No, that's fine.
I'll start with Nellum Tempest. Thank you. So the case law here is clear, and this is from Trimble and the other line of cases that we cited to. The Nellum Tempest doctrine exempts Chandler from all statutes of limitations unless the legislature has expressly and definitely declared that a statute of limitations applies to the state. And we certainly understand our WCD's argument that the all claims language means that we've accomplished that. The Trimble case says, no, we haven't. The Trimble case says a broad statute of limitations that applies to all claims of a particular kind does not apply to the state unless the legislature is so specified.
So here's my issue with Trimble. Trimble also says the legislature has to expressly declare that the Nullis Tempest doctrine doesn't apply, or that the statute of limitations does. And then you have Glen Eyre Electronics that comes along and says you don't need that express declaration. So it seems to me like there's some conflict there. The most recent case or instruction we have from our Supreme Court is that you don't need such an express declaration, and it seems like that was the sort of the key component in Trimble. So how do I reconcile those?
Sure. Glen Eyre is readily distinguishable. It is not the controlling case on our issue here today. Trimble is. And here's why. Glen Eyre is obviously distinguishable because the operative phrase that the court relied upon to say that Nellum Tempest has been overridden by the phraseology is, by implication, is notwithstanding any other statute. The legislature put that language into the statute at issue in Glen Eyre. That is not part of Section 12821. Notwithstanding any other under statute, that's an express statement by the legislature, and that happened to relate to the same chapter where we have the partial codification of Nellum Tempest. So the court concluded when the legislature says no other statute, and the statute in that chapter is the partial codification, the legislature has overridden Nellum Tempest as it has been codified. Completely different from our circumstances. Notwithstanding any other statute is not in 12821. And so,
But do you agree Glen Eyre Electronics says you don't need an express declaration from the legislature, and Trimble says you do?
I think Glen Eyre says that you need language such as notwithstanding any other statute, and we have that language in Glen Eyre. We don't have that in Section 12821. Which circumstance are we closer to, Trimble or Glen Eyre? That's pretty easy. It's Trimble. The statute in Trimble is exactly like ours, functionally. It's exactly the same. Section 44, 2004B, no civil action shall be brought under this article unless brought within 2 years. It's the same exact breadth as all actions in 12821. So I do think that to determine that Nellum Tempest has been overridden by Section 12821, this court would have to say Trimble is no longer good law. And I don't believe Glen Eyre causes that result at all. There's a very significant distinction in those two cases, notwithstanding any other statute. That is the prefatory statement by the legislature in that statute of limitations. That's the reason the court made the decision that it made, and that's the distinction.
So later you have the legislature, I think it was later, enacting the public monies statute, which is 35212. Most public monies claims are going to be brought by public entities. And the legislature says in that statute that the chapter entitled that 12821 is contained in applies to public monies claims. Why would the legislature include that when most public monies claims are going to be brought by public entities if 12821 then just doesn't apply because of Nullis Tempest?
I don't know, but the legislature might have thought some claims will not be brought by public entities, and maybe the legislature just didn't consider the issue. I mean, we have to all acknowledge sometimes that happens. The legislature does not think about the interplay among all these things. So I certainly don't think that just by saying that 12821 is going to apply to certain types of claims, many of which would be brought by a public entity, that's not your clear and definite declaration by the legislature.
Here's another clue, though. The legislature in 2019 amended 35212G, which to say that public monies claims by the AG on behalf of the state, which is a public entity, are governed by a 5-year statute of repose. Mm-hmm. And then our Supreme Court in Brnovich versus Arizona Board of Regents says the purpose for the legislature doing that was to make clear that the AG on behalf of the state is not governed by the one-year statute in 12821. Again, why would the legislature do that if 12821 doesn't apply to begin with, because the state is a public entity?
Well, what the legislature says, and this is section 35-212E, I think that's what you're referring to, Judge Catlett. It says if the action is brought by the Attorney General, the action must be brought within 5 years.
Right.
Okay, so that is the legislature making a clear and definite proclamation that a particular kind of claims, if brought by at least one particular arm of the government, is subject to statute of limitations. And that shows you the legislature can do this. We don't deny that the legislature can override nullum tempus, but they have to do it with specific language like they did in section 212E.
But aren't we rendering that statutory change superfluous?
No, because otherwise we wouldn't have the 5-year statute of limitations for the Attorney General if they didn't include that.
But why include it if the Attorney General has all eternity to bring a public monies claim because the state is protected under the Nullus Tempus doctrine? Because the legislature apparently sees that it's appropriate that such claims be brought within 5 years. That's the judgment that they made. And we can question what the policy behind that is, but that's the language of the statute. For these kinds of claims brought by the Attorney General, 5 years. If they put that into 12821, we'd have a 5-year statute of limitations for Chandler or whatever public entity they identified. So that's all readily reconcilable. And again, I just want to underscore in Trimble, statutes of limitations in public enforcement actions as opposed to criminal prosecutions do not run against the state unless the legislature has expressly and definitively declared that they do. And there is simply no distinction between our two statutes in terms of our analysis here. We've got some very strong suggestions, and it's dicta, and we identified it as dicta in our briefing, but Mayor Unified School District, Stewart v. Lang. Just again, though, Glen Eyre Electronics then clarifies that the legislature need not, quote, expressly declare in a statute of limitations that the state and its political subdivisions are subject to its provisions. So how's that consistent with, how's Trimble, that statement in Trimble you're relying upon, consistent with Glen Eyre?
Glen Eyre hinged on that prefatory statement, notwithstanding any other statute. So the court found that that was good enough. And we don't have that in our statute here. That's the distinction.
So just to put sort of a final bow on that, it seems to be what you're saying is that the Supreme Court, although it used additional language to say more broadly than the case before us, the legislature need not provide such an express or clear statement. Your contention is because the case before the Supreme Court included that specific language, effectively its judgment was passing only on that specific language, the notwithstanding language.
Its judgment was that the decision in that case hinged entirely on that prefatory language. And so that's the distinction. That's the difference. And we have the Lane case where the very clear implication is if the plaintiff had been a governmental entity in that case, the claims would not have been barred by 12821. They were in that case because a non-governmental plaintiff was trying to invoke nullum tempus, and the court said that doesn't apply here.
You want to talk a little bit about Henshaw and Builder's Supply?
Yes, thank you. So in terms of the accrual of claims, Builders is dispositive. And the rule of law, and this is binding Arizona Supreme Court precedent, a cause of action accrues in the terms of the statute of limitations each time defendant fails to perform as required under the contract. And what we've got in that case is we've got a defendant serially underpaying the plaintiff over the course of years, okay? Some of those claims grew stale under the statute of limitations. It was a 6-year statute of limitations in that case. When he finally got fed up and filed suit, the court said, the newer claims, those accrued within the 6 years, you get to pursue those. Each refusal to provide water when required under the Domestic Water Services Agreement is a separate breach, a new accrual of claims.
There's no discussion in Builder's Supply about knowledge on behalf of the wronged party, though. And part of me worries it's a case that predates Gus Rosenfeld by 20 years, and so accrual for purposes of contract claims based on knowledge of a breach, maybe that wasn't even a thing back in the 60s. So I guess your comments on that and how we can feel comfortable applying that case to modern times post-Gust Rosenfeld and in the context of 821.
Yeah, well, so 821, even if it applies, we're going to assume for purposes of argument, we've gotten past nullum tempus. Even if it applies to a claim within 1 year of the accrual. That doesn't impact the builder's applicability. Each year when we ask for water and they say no, if it's a breach, if the water is obligated to us under the contract, that's a new breach.
I mean, but do you agree with me, there's no discussion in builder's supply about whether and when the plaintiff knew that the breach had occurred? They just said it's a 6-year statute. We look at when the case was filed, and you can do anything you want within the prior 6 years.
I actually don't agree with that, Your Honor, and let me explain why.
Sure.
And this goes to one of the arguments that RWCD makes, and it's that, hey, our 2018 letter was an anticipatory repudiation that changes the analysis. And this is kind of in the same area that you're talking about. And the quote that I wanted to describe in response to that attempted distinction is directly responsive to your question. And this is a quote. Perhaps plaintiff might have considered the underpayment of November 1948 as a repudiation or anticipatory breach and brought suit at that time for all his prospective losses, but his failure to do so did not deprive him of his legal right to recover each deficiency as it appeared. Seems pretty clear to me that the court believes that the plaintiff understood that this breach was occurring year in and year out. And the court says he didn't have to sue initially. He might lose some claims after 6 years, but when he gets fed up, he can go ahead and file suit. And by the way, that's the law in the Henshaw case, which you just referenced a minute ago. The facts are really similar to ours. It's really amazing. The plaintiffs asserted that they are to their continuous injury deprived of the water to which they are entitled. And the court held that even if the statute of limitations prohibits certain claims that were earlier in time, that would not prevent plaintiff from obtaining an injunction to prevent future harm. And so, again, they have this tennis ball analogy. The Arizona Supreme Court has long considered the concept that a plaintiff might know he's being wronged by breach of contract or by some other deprivation of water and may choose not to file suit, and that may have outcomes related to whether there's a statute of limitations issue for the earlier breaches, but it does not prevent the plaintiff from, when he's finally fed up, filing suit on the claims that are more recent in time and do not fall outside of the statute of limitations.
Doesn't that cure any real application of statutes of limitations if all it takes? I understand you lose what came before, but if you want to keep your claim alive, you just ask for it, and then that revives your time. We're not playing any case.
I think what you just described, Judge Howe, is correct. And under this, the way this works, when claims accrue, yes, if RWCD continues to not perform and we continue to ask for water, a new claim accrues each time, and so that is the answer. And you know, this feigned concern about what would happen in 2085, you know, if RWCD, we were very clear, and we were very clear that we don't accept this. You are in breach of the contract. We don't accept that the contract's terminated. We're going to pursue. We're going to maintain our rights. All of those things. If RWCD were concerned about what happens in 2042, when we've got a new general manager and things have changed, they could have filed a declaration judgment action, and they didn't do that. So,
my understanding is you have an anticipatory repudiation. Your client then gets to decide whether to treat that like a breach or whether to continue to urge performance. Your client waits a year. In 2019, it says, no, really, we'd like you to deliver water for 2020. 2020 comes and goes, no water. At that point, isn't that a material breach of the agreement?
Under anticipatory breach, the non-breaching party gets to decide when to proceed on legal remedies related to that anticipatory breach.
At that point, you have repudiation and you have a material breach by non-performance. So why is that not enough at the end of 2020, so I guess January 1, 2021, to start the statute?
If 12.821 applies, which we obviously don't agree that it does,
right.
if it applies, we would agree that pursuing claims related to a 2020 breach would be barred by the statute of limitations. Okay, that's not what this case is about. This case is about seeking specific performance related to a breach that occurred a month before we filed suit. And that's Builders. That's Henshaw.
I guess another issue I have with Builders and Henshaw is they seem to me like continuing wrong cases or continuing breach cases. And in a case called Watkins v. Arpaio, at least with respect to the continuing wrong doctrine, we rejected the application of that doctrine to 12.821 and said no, 12.821 means when you know you've been injured and you know the source of it, you have a year to bring that claim. What do we do? So what do we do with Watkins?
I confess I'm not familiar with the facts of Watkins, so I can't distinguish it for you, Your Honor. But again, we've got cases that say, we've got a new breach in 2022. That's undisputed. And so the question is, are we going to throw out Builders and say, breach a contract, as soon as a defendant breaches the contract, that party no longer has to perform under the contract?
Sorry to interrupt. Do you agree with me that there was a material breach when, and regardless of what the legal implications of it are, there was a material breach when Chandler or the district didn't deliver water in 2020?
Yes. Readily concede that. I think we say that in our papers.
But your view is that you may lose on that claim, but you can always revive your claim. I'm concerned that how broad that rule can apply in all kinds of cases. This is just off the top of my head, but if you have a contract to sell a house and the seller doesn't sell you the house, can you later on ask that the house, let me buy your house, and then you've revived your claim?
Here's the difference. The Builders rule is it relies on separate and discrete obligations that occur from time to time. In this case, it's typically year to year, and that's what was happening in Builders. There was a periodic obligation for the defendant to make payments under the pay schedule on the contract, and each time the defendant underpaid, that was a separate breach. So your hypothetical actually is not a concern at all, because if you have a contract for the sale of a home and they breach that, there's no recurring obligation. It's not a contract that says we'll sell you the house every year, every November into perpetuity. That would be a bizarre case.
Yeah, thank you.
Yeah. I will move forward if there are no questions on Builders at this point. Thank you. I do want to talk for.
I guess, sorry,
No.
I said you can move on, and now I'm asking a question.
I'd rather answer your questions and go to my notes.
Do you agree that 12.821 is a limited waiver of sovereign immunity?
I don't know the answer to that. Never thought that through.
I mean, generally the statutes in and around 12.821 deal with claims against the government. I guess, would the district ordinarily have sovereign immunity as to your claims?
I don't know the answer to that.
Okay. I guess, and the reason I'm asking is the purpose of the statute is to make sure that claims against government entities are brought quickly, because the statute really is a limited waiver of sovereign immunity for some period of time. How is your theory that the city could bring a claim 83 years later, consistent with what the legislature was probably doing with that limited waiver?
Well, again, if a claim was brought 83 years later, that would mean that there was a new breach and a new accrual of claims. And so, again, it comes back to each time they breach a separate discrete obligation, the clock starts again. So I don't think that's inconsistent at all. If you have a contract that spans 50 years and there's a series of repetitive breaches, that does not implicate any bad policy as it relates to waiver of sovereign immunity, making sure claims are addressed timely, because it would have to be addressed within a year. We filed within a month. I mean, that's some of these hypotheticals just aren't really applicable here. I do want to talk very briefly about the notion that specific performance is not appropriate here. And the starting point is this is an abuse of discretion standard, and the trial court did not abuse its discretion. The argument is that there's some discretionary language in the Domestic Water Services Agreement that makes it too indefinite, and that's just simply not the case. We have a section devoted to calculation of the water that is going to be delivered to Chandler. That's 3.5.3 of the Domestic Water Services Agreement. It's APP-010, and Exhibit B is referenced in that section, and it provides very specific information on how that's calculated. So the idea that we can't administer a contract that was in fact administered for years and years just doesn't hold up. There's no factual basis for that. The last thing, I'm out of time. May I say one thing? One thing. This public versus proprietary distinction that RWCD makes on Trimble and on latches simply does not apply. That is a notion, that is a legal construct that involves tort liability for public entities, has nothing to do with when you apply latches, has nothing to do with the Trimble analysis. This is a domestic water services agreement. Absolutely, this is of public interest and public concern. Thank you very much. Appreciate it.
You just add 1 more minute to Mr. Henry's time.
Oh, thank you. Thank you very much for that. First, we heard a lot about Trimble, and obviously I think Trimble has been clarified by opinions that followed, including Glen Eyre, and we've talked about that. But if we are to apply Trimble expressly, it is limited to actions that are brought for rights belonging to the general public. And I do think that does invite necessarily the governmental proprietary distinction.
What do we do with the cases, though, that say things like sewer service are public and not proprietary?
I don't know about sewer services, and that may or may not be true under case law that says that. I do know that in the case law we cited in our briefing that it has been established for eons that anyone acting in the providing of water service realm is acting in a proprietary fashion. And if you think about that, I mean, when you're providing water service, I know this from other cases, you're competing with private businesses.
This water is going to farmland or residential properties, or do we not know?
I don't know, and I don't think the record actually fleshes that out. I do know, and I think it's important to underscore that ultimately...
I didn't think it was going to residential, which is why Chandler pays an assessment on urban land.
It very well could. I don't know. But the point I wanted to make is, and I think it's been lost in the shuffle, is on the governmental proprietary distinction, not only is the city in this instance acting in the proprietary capacity of providing water service, but in this very instance, under this contract, it is expressly acting as an agent for private landowners. And I do think that is important for purposes of assessing what role is playing on these issues. And I do appreciate the court bringing to everyone's attention the Watkins case. I do think that has some bearing on the applicability of 12821. Back to builder supply. I think there are many good reasons why that Arizona Supreme Court case, at least on the statute of limitations issues, has been rarely, if ever, cited. And it may be because, as Your Honor well pointed out, the law on accrual and what have you on statute of limitations under Gus Rosenfeld and what have you has evolved quite significantly. Henshaw, I do want to tackle that one. That's right in my wheelhouse. That involves continuing nuisance or trespass. And as this court well knows, a cause of action for trespass or nuisance turns on whether it's continuing or permanent. If it's permanent, it accrues upon that act. If it's continuing, the holder of that claim can assert it later. I can't think of a more permanent, if you're trying to morph that theory into a contract theory, a more permanent trespass than one party to a contract saying to the other party quite clearly, we're done, we're out, we're not performing, and then not performing at all. That then triggers the cause of action if you were to follow the Henshaw case.
Thank you. We're done, too.
Oh, my goodness. All right. Thank you very much.
All right, counsel. Thank you for your excellent briefing in the case and for your helpful arguments this morning. We will take the matter under advisement and get you all a decision with appropriate dispatch. Thank you.
Thank you very much.